Hello friends, this is Dr. Sumiti Ahuja, Assistant Professor from Faculty of Law, University of Delhi. Now Section 3 of the Indian Contract Act talks about communication of proposals, acceptance and revocation. It says the communication of proposals, the acceptance of proposals and revocation of proposals and acceptances are deemed to be made by any act or omission of the party proposing, accepting or revoking by which he intends to communicate such proposal, acceptance or revocation, or which has the effect of communicating it. It simply is telling you the, if I may say, the mode of communication. The mode of communication. Section 3 deals with the mode of communication. That is, how would you communicate your proposal, how would you communicate your acceptance to that proposal, how would you communicate your revocation to that proposal and acceptance, right? It can be through any act or omission by which that person intends to communicate such proposal, acceptance or revocation, or which has the effect of communicating it, that is expressly, impliedly. Section 4 is one of the most, one of the lengthy provisions under this, under the general principles. So it says, when is the communication complete? In the previous provision, we just discussed that what are the modes of communication. Here we are discussing when is the communication complete. So the communication of there are three parts, first part, the second part and the third part. First part here is dealing with communication of proposal. When is the communication of proposal complete? The second part is dealing with when is the communication of an acceptance complete. Third is dealing with when is the communication of revocation complete. Here at this point I will highlight on the first two parts. First part says communication of a proposal or an offer is complete when it comes to the knowledge of the person to whom it is made. We just saw in Lalman Shukla versus Gauri Dutt, communication of an offer is complete when it comes to the knowledge of the other person, right? The second part deals with communication of an acceptance. Now here you have to understand that the second part is further divided into two parts. Communication of an acceptance is complete as against the proposer when it is put in a course of transmission to him so as to be out of the power of the acceptor. I am trying to tell you here that, for example, there are two parties X and Y, because this act was made in a period 1872 wherein there were no electronic contracts, right? People used to communicate through letters. So this part means that say X makes an offer, X is making an offer to Y. Now Y communicates his acceptance to X. It says the moment Y has posted that letter, that is he has put this letter in course of transmission so as to be out of the power of the acceptor, right? Communication of acceptance is complete as against X, right? Now between this time period wherein X has made the offer to Y, and before Y could communicate the acceptance to X, X has the time to revoke his offer. X, I will just summarize it, what I am trying to say. I am trying to say that X has made an offer to Y, and before Y communicates his acceptance to X, X has the right to revoke the offer which he has made, right? Similarly, the second subpart of the second part here is trying to tell you that communication of acceptance is complete as against Y when it comes to the knowledge of X, which means that when Y has posted his acceptance, before it comes to the knowledge of X, Y has the right to revoke his acceptance. That is why communication of an acceptance is complete as against proposer at a different time and as against acceptor at a different time. because revocation of proposal is also possible before acceptance is put in course of transmission, and revocation of acceptance is also possible before the acceptance reaches the offerer, right. Now this case, this judgment, Bhagwan Das, Govardhan Das, Kedia versus Messrs. Girdhari Lal, Parshottam Das and company, it's an important, as you can see on the screen, I have clearly highlighted that it is a landmark case on communication of acceptance in instantaneous modes of communication. Now, the rule, if I may take you to the previous slide here, if you just see this portion here, the second part, it is trying to tell you that communication of acceptance is complete as against proposer when it is put in course of transmission to him. So here it was being referred to letter, because I told you that it was a time when people only knew letters to be mode of communication, or communication in person was the rule. Here came this case, Bhagwan Das, Govardhan Das, Kedia, which was dealing with when is a communication of acceptance complete, when the acceptance is communicated through some instantaneous or fast mode of communication, faster mode of communication. Herein in Bhagwan Das, Kedia, it was telephone. So for the first time in Bhagwan Das, Kedia, it was laid down that if a contract is made through telephone, where is the communication of acceptance complete? Is it complete where the acceptor is, that is where the offer is heard and the acceptance is put in course of transmission, or is it complete at the place where the offer was made, from where the offer was made and now where the acceptance has been heard? So in Bhagwan Das, Govardhan Das, Kedia, it was held that if we go by as it is the language of section 4, it will mean that the moment the person on the other side who communicated his acceptance, moment he communicated, he spoke the words of acceptance on phone, the communication of acceptance was complete as against the proposer. What if the proposer did not even hear what the acceptor had said, right? So court held that in case of instantaneous mode of communication, the rule as it is, as laid down in section 4 cannot be applied. It cannot be applied, because herein in this case in instantaneous modes of communication, only till the time the offerer has heard, has received the acceptance, one cannot say that the acceptance is complete, right. So it is one of the important judgments, because first of its kind. Now coming to the concept of revocation. Revocation means to annul something previously done. You made an offer, you revoked that offer by saying I take back my offer. You made an acceptance to someone's offer, and then you say, then you wish to revoke that acceptance. You do not wish to continue with any kind of relation with that person. When can revocation take place? We just saw under section 4 that revocation can be of offer also, revocation can be of acceptance as well. Section 6 of the Indian Contract Act provides for mode of revocation of proposal. Number 1, the first mode, the most common mode of revocation of a proposal or revocation of offer is by communication of notice of revocation by proposer to the other party. That notice of revocation does not mean you are sending a legal notice. It means that you are communicating to the other person, you are bringing it to his notice, to bringing it to his attention that see, I do not wish to continue, right. I do not wish to continue, I would not be waiting for your acceptance, I take back my offer. Second is lapse of time prescribed in such proposal for its acceptance. That is, You gave the offer, you had mentioned a particular time period, that within this time period, within this time acceptance should be communicated. The time has lapsed. Failure of acceptor to fulfill a condition precedent to acceptance. So, in the offer, say it was mentioned that along with communication of acceptance, a token amount has to be paid, honest money, some token amount has to be paid. So, that was a condition precedent to acceptance. If a person does not fulfill that condition precedent. The fourth or the last mode of revocation as mentioned is death or insanity of the proposer, if the fact of his death or insanity comes to the knowledge of the acceptor before acceptance. Before the person could communicate his acceptance, he comes to know that person who gave me the offer is either dead now or has become insane, that is not of sound mind anymore. Then in that case, the offer automatically by default stands revoked. Even if now after knowing that the person is either dead or has become insane, you communicate your acceptance, that acceptance is of no value. I would like to conclude with this last slide here regarding e-contracts. So, e-contracts are defined as an agreement which is made electronically instead of physical meetings between the parties to the transaction through electronic mode via email, etc. Now, e-contract forms a significant part of e-commerce, which we all know. We do so much of shopping through e-commerce only these days. Same fundamental principles of Indian Contract Act are applicable. This last 2 points. In an electronic contract, the offer has been communicated once it has entered the computer of the offeree, and acceptance is complete when it has entered the system of the offerer. I would just make this last point and conclude my session. IT Act, that is Information Technology Act 2000, is a very important legislation here because it gives legislative validity or recognition to the e-contracts under section 10A, and in order to make any valid contract, signatures from both the parties are needed, and IT Act makes a reference for that thing to digital signatures as well, right? And there is this landmark judgment also you can see on the screen and can go through. With this, I would like to end this session of mine. Thank you very much.